Welcome back to Elise Explains IP, the show where we decode the legal, the technical, and the sometimes chaotic world of intellectual property into something founders, creatives, and growing businesses can actually use. I'm Elise Steegstra, a commercial lawyer and trademarks attorney, and today we're going deeper than just NDAs, because, let's be honest, an NDA is often treated like a magic spell. Sign this document and all our secrets will be safe forever. But in real life, that's not how it works. In today's episode, Beyond NDAs, Proactive Protection Strategies, we're talking about crafting agreements that actually hold up, building layered security around your IP, creating a culture of confidentiality, and yes, the open source software pitfalls that can blow up a commercialization strategy overnight. So let's jump into it. I'll be honest with you, I like NDAs. They're useful, they're expected, and they set the tone that information matters. But NDAs have limitations, and courts are not kind when an NDA is vague, overly broad, or unrealistic. The biggest issues that I see? Number one, NDAs that don't clearly define what is confidential. If you can't point to what is protected, a court won't either. Number two, NDAs that lack practical safeguards. If you treat your own information casually, the other side can argue it wasn't really confidential. And number three, NDAs that try and be a one NDA fits all and end up fitting nothing. So, how do you craft confidentiality agreements that actually survive scrutiny? Think of a strong NDA as a three-part tool. 1. Clear and specific definitions. Spell out what's confidential. Is it the source code, technical drawings, strategy, roadmaps, customer lists, pricing, prototypes, even information disclosed during meetings on ABC date? Vagueness is the enemy. 2. Reasonable obligations. If you demand the impossible, like ensure zero disclosure forever, courts see it as unrealistic. Instead, require reasonable steps, such as limiting access to authorized personnel, storing materials securely, and notifying you if there's a breach. 3. Practical remedies. Always include the right to seek injunctions, not just damages. By the time monetary loss is proven, the damage is usually done and the information is out there. These aren't just legal niceties, they're what make an NDA enforceable rather than aspirational. Now, let's talk about where businesses often trip up. You can have the world's best NDA, but if your security is a mess, it won't matter. The courts will look at what you did to protect your information. So let's talk about layered security, the combination of digital and physical protections that support your confidentiality framework. Digital controls, encrypted drives, remote wipe capabilities, role-based access permissions, multi-factor authentication, secure repositories for code, and even removing ex-staff access immediately once they leave. You'd be shocked how often this doesn't happen, and I've logged into systems in some places where I haven't been an employee for years. These measures show that you take confidentiality seriously. Physical controls also matter. Having locked rooms for prototypes, visitor sign-in procedures, controlled access cards, secure disposal of printed materials, and clean desk policies for sensitive projects. It doesn't matter whether you're a startup working from a co-working space or a scaling tech company. Layered control is what proves your information is actually confidential. But protection isn't just legal and technical, it's also behavioral. One of the biggest threats to IP isn't hackers or competitors. It's your own team, who often overshare without realizing it. Creating a culture of confidentiality from day one means, firstly, having training that isn't boring. Helping people understand why security matters and why secrecy matters, not just because legal said so. I've seen businesses use real competitor case studies to make the impact of loose lips really clear. Having onboarding and offboarding processes. Avoid the everything's a blur moment where the IP simply walks out the door. Ensure that your offboarding includes revoking access, collecting devices, and reaffirming confidentiality obligations. Also, normalizing good habits. Making sure that people aren't discussing sensitive topics in places they shouldn't be, so no conversations in elevators or shared spaces, checking who's on a Zoom call before launching into it, and using secure channels instead of just emailing documents to myself. Confidentiality should be part of your company's DNA, not an afterthought. And now, for a little bit spicy risk, open source risks. Developers love open source, and they should because it's efficient and it accelerates development and it prevents reinventing the wheel. But from an IP perspective, open source can quietly blow up your whole commercialization strategy if you're not paying attention. Common risks are things like copyleft licenses, like GPL. These can require you to share your entire code base if you incorporate certain open source components into your code. Secondly, having things of unknown provenance. Developers copying snippets from GitHub without checking licenses or without checking if they're allowed to use them can be a real risk. Also look at supply chain vulnerabilities, malicious code inserted into an open source package, which can often go undetected for years. Think about practical controls for this, like maintaining a register of where you've obtained code from, using automated license compliance tools, training developers on compatible licenses, and vetting open source components before integration. You should have an approval for dependencies. Managing open source isn't about shutting it down, it's about controlling it properly, so it doesn't control you. So, as we wrap up today's episode, think NDAs are a starting point. They're not a strategy. Real protection comes from having robust, enforceable agreements, layered digital and physical security, a culture where confidentiality is normal, and smart management of open source software. If you can nail these 4 things, you're going to be streets and lanes ahead of most businesses, and far less likely to face a "we thought we had protected it, but we didn't" moment. So, thank you for listening to Elise Explains IP. If you found this episode helpful, subscribe, share it with a founder friend, or leave a review. And if you have an IP question you'd like featured on the show, send it my way via my website. Until next time. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.